Welcome to Open Minds, a Freedom of Thought podcast series, interviewing the people who bring courage and independent thought to the challenges of today.
Welcome to today's Federalist Society virtual event. This afternoon, Monday, September 18th, we will be discussing the ABA proposed accreditation standard for academic freedom and freedom of expression at law schools. I'm Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. Today's program will focus on the role accreditors might play in supporting freedom of thought at law schools. Several recent high-profile incidents have raised questions about academic freedom, freedom of speech for faculty and students, and sparked some concern that our law schools have become culturally hostile to a range of ideas that are still very much in play within the larger legal system. Counsel of the ABA section responsible for the proposed accreditation standard describes their core concern as that the effective legal education and the development of the law require the free, robust, and uninhibited sharing of ideas reflecting a wide range of viewpoints, and that concerns about civility and mutual respect do not justify barring discussion of ideas because they are controversial or even offensive or disagreeable to some. Our panel will consider whether our law schools are meeting this bar for effective legal education and what the proposed standard might do to address any shortcomings. Directing the panel, we are delighted to have Justice Carlos Munoz, who serves on the Florida Supreme Court. Justice Munoz was appointed by Governor Ron DeSantis in 2019. He has held a variety of other positions of responsibility in federal and Florida administrations, including serving as general counsel for the U.S. Department of Education. As always, please note that all expressions of opinion offered today are those of the experts on today's panel. We encourage our audience to submit questions for the panelists through the Q&A feature at the bottom of your screen. Thank you so much for being with us today. Justice Munoz, the floor is yours.
Thank you, Alita. I appreciate it. And thank you to our panelists for being here today and for everyone who's taking the time to watch and listen to our conversation today. It is going to be a conversation. We're not going to have prepared presentations from anyone. So I will quickly introduce our panelists and then we'll get started. First up, Daniel Thies is a shareholder at Weber and Thies in Champaign-Urbana, Illinois, where his practice focuses on complex commercial litigation. He's long been active in the Federalist Society, and more importantly, for purposes of today's discussion, he's on the executive committee of the ABA section of legal education and admission to the bar, which is the nationally recognized accrediting body for American law schools, as Alita mentioned. Next, we have Professor Nicole Garnett, who's the Associate Dean for External Engagement and the John P. Murphy Foundation Professor of Law at Notre Dame Law School. Her scholarship focuses on education policy and property law, and in particular, she's done a lot of work on issues affecting Catholic and other faith-based schools. Next, we have Professor Benjamin Edelson from Harvard Law School. His work focuses on public law and issues at the intersection of law and philosophy. His recent scholarship includes an article that's titled The Etiquette of Equality, which has to do with norms and discussing difficult topics in law school settings and other settings. And I think it's obviously very relevant to today. And finally, Professor Joshua Kleinfeld from Northwestern Law School, who's visiting this year at the Scalia Law School at George Mason. He teaches and writes in three areas: legal and political philosophy, legislation and statutory interpretation, and criminal law and procedure. And I know he also has a great interest in free speech and First Amendment issues. So Daniel, let's start with you. If you could please describe for us what the standard is, how it changes the status quo, or how it would change. So let me just, to be clear, it's been put out for comment, so it hasn't been adopted yet. What it is, how it would change the status quo, and what prompted the organization to propose it.
Sure. So first, just as a bit of background, the ABA Section of Legal Education Council, on which I serve, is the nationally recognized accreditor for the first degree in law by the Department of Education. And in addition to that, the council is recognized in some way or another by every state Supreme Court in the country, and that if you get a degree from an ABA accredited law school, that qualifies you to take the bar exam in each state. So that's the ABA, just from the get-go, I'll say, is sort of a quasi-government actor in that way, but not actually exercising government regulatory authority. Rather, we are just putting out our view of what a good law school is, and the state Supreme Courts recognize that. So related to that role, we promulgate a set of standards. There's a book that comes out every year, looks like this, with all the standards in it that law schools have to comply with. Currently, they address academic freedom only in one small part, which is standard 405B. And it currently says that as a law school, you have to have a policy on academic freedom, full stop. It doesn't say what the policy has to include, and it doesn't even say you have to adhere to the policy. So over the last several years, there's been a growing sense in the ABA, and I think in the academy more broadly, that the standard should include more protection of academic freedom. And that's really for two reasons. And they come from two different political angles, if you will. So one is that on the right, I think there's a lot of concern about the atmosphere on law school campuses when controversial speakers are not allowed to express their opinions, or if students and faculty are hesitant to discuss controversial topics because of fear of giving offense. We found occasionally that concern even inhibits classroom discussions, in constitutional law courses or otherwise. That's a concern that the council's had, as I said, for a couple of years, even stretching back before the more recent high-profile incidents like the one at Stanford involving Judge Duncan, where invited speakers were not allowed without interruption to give their remarks on campus. So that's one set of concerns. Another set of concerns really coming from the left is the concern that there are a number of legislatures and or university boards in a number of states that are, for example, banning the teaching of critical race theory or otherwise trying to restrict the teaching of certain viewpoints in the classroom. And both of these trends represent a unique threat to the project of training lawyers. Our view as the council is that lawyers are the profession that addresses disputes over controversial topics in our society, and therefore we can't teach students to shrink from controversy. Rather, professors must be free to teach and discuss controversial topics, and students have to learn how to confront offensive or controversial positions respectfully so that they can understand the opposing point of view, and if you're in a court of law, confront it and show why it's wrong. Shouting down or avoiding a contrary position cannot be good for the training of lawyers who are tasked with doing that in our society. So that is really the motivation behind the proposed standard. As Justice Munoz mentioned, the proposal is out for notice and comment that closes, the comment period closes in just a little bit over a week. So this is not adopted yet, but the current proposal, subject to change after the notice and comment period, broadly comes in three parts. It's a new standard 20A, and it has an A, B, and a C. A addresses academic freedom, and it says now that a law school has to adopt, publish, and adhere to a written policy to protect academic freedom. And then it outlines kind of the bare minimum that such a policy has to include. It has to apply to all teaching faculty at the law school. And it has to apply to a broad range of activities, teaching, research, et cetera, governance. And it also has to afford due process to assess a claim of violation of the academic freedom policy. So that's A, addressing academic freedom. As I said, it applies only to those who teach, the faculty in the school. B is more broad in that it addresses free expression and would apply to everyone in the law school, faculty, students, and staff. And again, the law school is required to have apply a policy, and there's a set of bare minimum things that it has to include. So protecting the rights of people to communicate ideas that are controversial or unpopular. And it also must prescribe disruptive conduct that hinders free expression by interfering with law school functions. So that's A and B, academic freedom, freedom of expression. And then subsection C is kind of what I'll call the First Amendment exceptions. And what it is meant to do is to say that a law school's policy, consistent with the standard, may restrict speech in a number of different ways. And in here you will find traditional First Amendment doctrine type ideas like reasonably regulating time, place, and manner of expression, right, for example. It also says that law schools can restrict expression that violates the law or that defames an individual or constitutes a genuine threat or harassment or unjustifiably invades substantial privacy or confidentiality interests. And then finally, subsection C also says that a law school may adopt a policy that reflects its unique mission, including a religious mission. And that's in there reflecting the idea that institutions have First Amendment rights of association as well. And so we are recognizing the right of an institution to gather around a certain set of ideas, and those may be incorporated into its academic freedom policies. I'll just note briefly then there's a set of interpretations that follow the standard language. Standard or interpretation 2085 in particular mentions that subsection C is meant to allow law schools to restrict speech consistent with the First Amendment. So it's sort of importing into the standard the set of ideas that have been developed in First Amendment jurisprudence. So that's a very brief overview, Justice Munoz, and I'm looking forward to questions and the discussion that's going to follow.
Great, thanks so much for that introduction, Daniel. So let me just start. We're going to get into some of the details here in this proposed policy and discuss what our panelists think about the merits of some of this. But let me just ask kind of broadly, focusing on the academics on the panel. Do you, before we kind of pick it apart, do you welcome this as being something that's kind of added to the accreditation requirements for law schools? Do you think that, obviously subject to whatever qualifications you have about how you might interpret it, but just as a general matter, do you think that this is a good and necessary thing to be added to what to the criteria that are part of how law schools are evaluated? Why don't we start with you, Josh?
Thanks. I admire the standard and welcome it very much. Just on a personal level, I've taught at a lot of law schools. I've taught at Northwestern Law School for 12 years. As you said, I'm a visiting professor at Scalia George Mason this year. Previously, I've taught at Harvard and Stanford. And I can tell you that I, just on a personal level, I feel unfree. And I know many, if not more than many, overwhelming majority of my colleagues feel unfree in the classroom. Something has changed in our culture and in our institutions to create a pervasive sense that discussions are ringed by taboos. Now, I don't want to speak for everyone. Of course, people have different experiences of this, but it's diminishing the quality of education we can provide to students. It's also taking out the fun of batting ideas back and forth without fear of personal repercussions. And so I think something has gone awry in the culture and in our institutional structures, and this action by the ABA is a much needed correction.
Okay, Professor Garnett, how about you?
I, like Josh, I welcome this. I think it's important. I've been fortunate. I've spent, with the exception of one semester at the University of Chicago, my entire teaching career at Notre Dame, where I think we actually have robust conversations. I mean, and I feel fortunate that I don't have that same fear, I think, that Josh expressed, although I think if you are a law professor and you read enough, there has to be some lingering anxieties. One of the reasons I think we've been able to have a robust discussion at Notre Dame is that we've always been pretty clear, especially with our current dean from the outset, about how important robust discussion is. And so there's two things about this policy that I think are important. The first is it asks law schools to state up front what their policies are. For example, a religious institution, do we have any exceptions to a free speech policy or academic freedom, to say it up front so that people who are joining our community understand that. But it also invites us to tell the students and our faculty from the beginning that we are, not only are we fully committed to robust debate here, but we are required to be fully committed to it. And so I think that gives us, it's a really nice invitation for welcoming new community members, including students. And I think, anybody who's watched what's happened over the last few years at our alma mater, Justice Munoz and others, we have to be, I think, there has to be some sense of what is going on with, disruption and protest and shouting down speakers instead of shutting down robust debate. And so I really applaud the ABA for making clear that law schools need to adopt a policy to prevent that kind of disruption, while at the same time enabling and welcoming and protecting counter speech.
Professor Edelson?
I agree with lots of what's been said. I mean, I suppose I don't have a theory of accreditation as a, I'm taking the question more as, would it be good for law schools to do the things that the standard specifies? And I suppose there's a separate question, as among the things that would be good for law schools to do, which should be made a condition of their being accredited law schools at all. And that seems like a hard and interesting question about which I don't have a general view. So I'm agnostic as to whether this belongs in a standard like that, but whether it's a thing it would be salutary for law schools to do it. I think so. I think clear rules about these things are valuable. Enforcement of the rules is valuable, in part because it avoids charges of bias, and makes clearer to everybody in advance what the repercussions of choices they make will be. In terms of the classroom environment, I think I can empathize with aspects of what Josh and Nicole each said. I'm not oblivious to the feeling of Josh was calling them taboos. I say risks of unintentional offense or communicating something other than what one intends. I think there are lots of ways of communicating things other than one intends, in ways that students sometimes reasonably, sometimes maybe unreasonably take offense to in ways that are problematic. So I think that is a challenge. I would think of the task or the challenge overall, I think in a slightly broader way, less as sort of like, how can we make sure there's robust debate, and more like, how can we make sure that there's robust debate? I think Nicole was getting at this at the end, in a context that still, that doesn't put that in opposition with everybody's sense of feeling welcome and included and respected in this institution in which they're being asked to invest a lot of their time and identity. And to me, the challenge is accomplishing those in tandem.
Great. So before we get into the details, Daniel, something that that Professor Edelson mentioned made me curious. When you guys were formulating this, did you have a lot of discussion about, to the extent that this is going to have teeth, if it's to be adopted, and it would be a basis for evaluating schools? How would you anticipate deciding whether schools are, quote unquote, adhering to these kinds of policies? For example, for making sure that there's robust debate, or that robust debate is possible.
Yeah, well, I'll start by saying this would not be the only place in the standards where we require schools to adopt, publish, and adhere to a policy. There are a number of them, and actually prominent among them perhaps is the non-discrimination standard, Standard 205. And in some ways, I see the enforcement of this standard being similar, in that our goal would not be to stand as a reviewing court for every complicated free speech or academic freedom question that lands on the dean's desk, right? Institutions should be free to make judgment calls. They're closest to the facts. They understand the players involved, the faculty, the students, et cetera. Administrators need a fair amount of flexibility to address difficult situations. And so obviously we'd have to give some deference to that. But what we are requiring is that there be a policy in place, that it meet these requirements, and that you enforce it. So of course, you do have to do some line drawing, and there's comes a point where a school's enforcement of a policy is so lax as to be almost non-existent. And I think in that case, we would follow the same process we do with these other places in the standards that I mentioned, where there's a potential policy violation, which is to say we send the school a letter and say, hey, we suspect you might be out of compliance with this standard. Please explain to us how you're not. We get a response back from the dean, and we review that with all the information the school's provided and decide whether we think that's in compliance or not. If we think not, then we have a hearing, and the school gets to come in and present its case live and have some back and forth question and answer with us about the violation. If after all of that, we still think they're in violation, there's a number of sanctions we can impose up to and including removing from the list of recognized law schools. But of course, the goal is, I think, before that, to get the school to change its policies so that it's actually in compliance, right? And so I see a similar process here. And we would try as much as possible to stay out of the individual questions so long as the school is within the range of making reasonable judgments and applying its policy.
Okay, that's helpful. Okay, so as far as the details of the policy, Daniel mentioned that subsections A and B set out the requirements, A for academic freedom, B for having the policy to respect the free expression of ideas among all the people in the law school community, faculty, students, staff. But then subsection C does have some provisions about some areas in which restriction of expression could still be permitted under the policy. And so one of the specific things that's listed here is that schools, notwithstanding the policy, would still be able to restrict expression that constitutes a genuine threat or harassment. And as Professor Edelson mentioned, there's obviously issues about kind of, what someone, objectively might perceive as harassment versus, more kind of objective standards and, how people would draw those lines. But we thought it would be helpful to discuss just, how, what would be kind of the best way to interpret that concept of restricting harassing speech in a way that kind of balances where the pedagogical needs of the institution with the goal of this policy to, have some, basically promote the idea of, give and take that may be, unwelcome to some, but that's still necessary to pursue kind of the education that's going on. Professor Edelson?
Yeah, it's a hard question. I mean, I'm as I'm looking at the text now and thinking about your question, I suppose I'm tempted to distinguish, and I don't know if this is the intent of the standard or not, and that would be interesting to just sort of think out together. But I would be tempted to distinguish sort of a classroom setting in which, there's pedagogical judgments are so pervasively a part of, in effect, who I let speak about what for how long, that the idea of subjecting those judgments or that speech to a kind of non-discrimination principle seems hard to even kind of get off the ground, because of course I can sort of shut a student down when they're saying something that just seems unhelpful, or confused or wrong. And so, if it seems to me confused and unhelpful and wrong because it's racist or something, like it doesn't seem that different in kind. It doesn't seem maybe to me amenable to the same sort of parsing that this contemplates. Whereas this seems to me to have a cleaner application to, sort of what happens within the law school community, but outside of the kind of structured speech situation of a law school class. So, when can the school discipline a student for what they say to another student in another setting or something like that? What kind of email can get you, disciplined by the school because from the school's point of view, you're behaving in a way that makes it, compromises the school's commitments to other students about the kind of environment they can expect. So I wonder if there's like a kind of core pedagogy kind of carve out from this, or how the drafters of the standard pictured that distinction, if any, and maybe that would inform some of the questions that you're asking about.
Nicole?
So it's a great question. I mean, I think obviously as lawyers, we wonder whether this there's a danger this is the exception that swallows the rule. And I think so I'd say two things: defining and making clear what a genuine threat is a little bit clearer to me than harassment. So I think so just defining, like Ben says, in the classroom, if I have a student who says something that's controversial, that makes another student uncomfortable, I would certainly hope that that would not be, deemed to be harassment, nor would it be on me to necessarily ask the student like to shut off that kind of debate. I teach education law, for example. So there's lots of really controversial issues in education law. And if we aren't allowed to talk about them, we're not having an education law class. So I would hope that, but I think part of it is defining it. The other thing I think might be something that, and I don't know what the line is. So it's related to my second point, is how this standard interacts with other disciplinary processes within a university, in particular, the sexual and racial harassment apparatus for Title VI and Title IX. So at Notre Dame and in many other schools, we have like sort of we have an anonymous tip line. You can just, it's like speakup.nd.edu. And if somebody says something that you find to be racially discriminatory harassment or sexual harassment, you can tell the Office of Institutional Equity, and that will trigger an investigation. Sometimes that investigation is just like a phone call and it goes away, but it's still like pretty freaky if you get the phone call for something you said in class. And the Biden administration is now proposing the proposed Title IX regs for sexual harassment would change the standard for sexual harassment, what constitutes sexual harassment, from an objective to a subjective standard, which I think I would prefer an objective standard. I'm maybe that's just a higher bar. And also, clear and convincing versus preponderance of the evidence. So if you have a subjective standard in Title IX, and then you also have a lower burden of proof, these things might interact where the university DEI, institutional equity, student disciplinary processes are working at cross purposes to what the ABA is trying to accomplish here.
Josh?
I want to pick up on a thread of Nicole's comment, which is the interaction of the proposed Rule 208 with the increasing power of offices of equity at universities. So many of the people in our audience who went to college and or law school, let's say 10 years ago or more, might not be aware of what an incredible institutional and formal change in law school structure these offices of equity are. It's natural for everyone to anchor their understanding of college and law school from their own experience, and to imagine that the differences are sort of sedimentary and not differences in institutional structure. But that isn't quite right in this case. Offices of equity are, they might have been non-existent or scarcely a part of your college or law school experience, and now they are a really major part of how many, many institutions function. DEI officials are not minor officials. They're powerful, highly paid officials in well-staffed offices. They are not greatly deferential to professors, in my experience, and they tend to be ideologically aligned with the DEI movement. And there tend to, in most universities that I'm aware of, there are discretionary and mandatory processes. So let's say that someone says something in the classroom or any otherwise, a faculty member, say, or a student, that strikes at one of our familiar identity-related taboos, usually involving gender, sexuality, or race. And another student gets offended. What will routinely happen, sociologically it's quite predictable, is that the offended student will file a complaint with the DEI office at their university. Those complaints are typically anonymous, as Nicole was remarking, even at Notre Dame. And they trigger, in many cases, a mandatory investigation, again, as Nicole pointed out at Notre Dame. And how that investigation turns out will depend on the context and the officials and what was said by whom. The DEI offices do have formal powers of sanction. They also give professors and students a talking to. They put things in the permanent record. You know how when you were in grade school or high school, you might have gotten in trouble and they said, this could go in your permanent record. Well, there is now a permanent record. I never knew what the permanent record was when I was in 8th grade, but now there is a permanent record and it is carried by the DEI office. And sometimes, by the way, the DEI office does just exonerate people. But, and again, picking up on a thread of what Nicole said, There's a great book by Malcolm Feely on criminal law, and the title is terrific. The title is "The Process is the Punishment." So the investigation itself is a sanction. It quite reasonably scares and upsets people. So I have a suggestion in this regard for an emendation, for an adjustment to proposed Rule 208 and its associated interpretations. My suggestion is that 208 should add that universities that house law schools must clarify their DEI investigation policies to make sure the discourse of the kind that is protected by Rule 208 is not subject to DEI investigation, even if there is a complaint. In other words, 208 carves out an exception to the investigation process. I think that's necessary to make this standard effective in the context of modern university DEI offices. And note, just one comment on my proposal. The ABA as an accreditor is acting within a context of state and federal law. And when it advises universities about their accreditation, law schools about their accreditation, it has to do so in a way that respects state and federal law. But these DEI offices and their processes are matters of university policy, not state and federal law. And to say that if you're a university that houses a law school, and if indeed law schools are committed to the discussion of difficult ideas as they should be, the university can't be having DEI investigations on the basis of things protected by Rule 208. So that's a suggested addition.
Daniel, have you guys had any interaction with the Office of Civil Rights at Education over this kind of stuff? I mean, it seems like I like the idea of what Josh is talking about here, but I'm wondering if OCR would sort of take a different view of, if they would agree that, the Title IX policies or whatever need to kind of yield to this stuff.
Yeah, I mean, that's obviously a tension that I think is likely to come up in the enforcement of the standard, even without the proposed amendment, which certainly something we would discuss as a committee. But I will say that interpretation 2086 does put at the center of the concerns that the standard is trying to address the rigor of the educational experience, so that we are training good lawyers, right? So then this gets a little bit to Professor Edelson's comments as well, but so I would certainly think already that to the extent what Professor Kleinfeld is describing chills speech in the classroom and limits the rigor of the experience that the students are getting there, right? The robust exchange of ideas, which I think is really the core of what we're trying to protect here in a classroom setting, well-training lawyers. Then I think that there would legitimately be some friction with the standard as written. And I'll point out there is another standard that speaks to the relationship with the university. Standard 201D says that the policies of the university that are applicable to the law school have to be consistent with the standards. So I could certainly imagine this issue coming up if faculty or students at the law school, for example, say, well, we couldn't have a robust discussion about Roe versus Wade and Dobbs and abortion in the constitutional law context because we were all worried about being cited by the university's DEI office. That would be a concern, I think, and something that the standard would rightly address. So I think that's just some general thoughts on how we approach it. I don't think it'd be possible or helpful maybe to give a complete account of how that tension would be worked out, but rather this standard would simply say there are important values on this side of the debate as well when we're talking about diversity and inclusion that DEI is trying to protect. That's important also, but academic freedom, freedom of expression is also important, and both of those need to be at the table when we're trying to mediate these difficult situations.
The key thought, if I may, the key thought is that Rule 208 cannot effectively protect freedom of expression if you can be subjected to investigation for the things you say, things that would be protected. And I don't think that puts the ABA or Rule 208 in tension with Title IX or Title VI. I think it just puts it in some tension with some universities' DEI policies, which is a very different thing.
Right. Yeah, and in that case, I think under 201D, the policies of the university would have to yield. Now, of course, the devil's in the details about how that would be applied in any particular case. But I think it's fair to say that legal education here is different precisely for the reasons I stated, that we're training professionals to address controversial topics. And so the education can't be completely devoid of discussion of controversial topics, even those that offend or that are perceived as harassment by some. So
the way to think of it is that Rule 208 is a safe harbor against both sanctions from the DEI office and investigation by the DEI office, the investigation being itself a sanction.
So I just want to say one thing, push back a little bit. I don't think it's that any of it's meant to say this, but I think we should be careful that we're not saying the protections are limited to the classroom, because I mean I don't understand. I have adult children now, but and I have taught law students for a long time, but I hear stories about fights in group me chats where I don't understand why they do that, oversharing in the group me chats. But if somebody says something controversial in the first year group me chat, I think that should be protected, and because in some ways, maybe this is to your point, Josh, about going your law school experience is set in when you're in law school. We didn't have a group me chat, but that could be an important part of the discourse and debate among a group of people could be taking place in social media, or other things, or in the commons over lunch. So I think we're going to make sure that we don't just limit. We're protecting classroom speech, and we're protecting faculty members' ability to write what they want, but we're also protecting student speech outside the classroom, because that is an important part of how they interact and learn. You want the classroom conversations to continue.
Can I pick up on an aspect of that and an aspect of what Daniel was raising? Daniel raised this, I think, helpful sort of hypothetical or not hypothetical in people's experience of students who feel like they can't have the kind of discussion or pedagogical experience around, say, Roe and Dobbs that they wish they could have, or that pedagogically we feel they ought to have, because they're afraid of being cited by a DEI office or something. That isn't my experience. My experience, I mean, I don't mean this boastfully. I feel like actually my con law class, we do have pretty robust discussions of those issues, and everybody seems to be fine. But to the extent that there is a chill, and I certainly think there is some, what I hear, particularly from conservative students, is not, I'm afraid I'm going to be hauled in front of a disciplinary board, or I'm afraid I'm going to be, formally sanctioned or something. It's more, to Nicole's point about the group me chat, it's more like, I don't want to appear to my peers to be kind of, benighted and a pariah for the views that I have about some of these issues. So the prudent thing for me to do is not talk about them. And I think that's the thing that does more to put a gap between the academic experience in and out of the classroom that law students are getting and what we might wish they got, than the formal sort of institutional processes. Maybe faculty are a little more worried about the formal institutional processes, but my sense of the student experience is not so much about that.
May I respectfully disagree then? I imagine you in particular run a really fair-minded constitutional law class and probably get more robust discussion from both sides than some. But there's a lot of statistical evidence at this point based on carefully conducted surveys. I wish I had them at hand. I didn't expect to need numbers, but both in the university as a whole and in law schools in particular, showing that conservative students shut down and do not express their views openly in the classroom, not just in private settings. They do it in both settings, but they do it particularly in the classroom setting, or among other things in the classroom setting. They do it because of fear of both what the professor will do and their peers will do outside of the classroom setting. And the chill is in full effect, I think. Also, within the, I'm in the Federalist Society, and within the Federalist Society, I help lead a group of sort of young, untenured professors. I'm tenured at this point. I started it right after I got tenured. And I can guarantee you, I think I've spoken to every FedSoc associated untenured professor in America, or close to. And they are scared to death about formal sanctions. And I can tell you that it was a couple of years ago now. I have to be careful what I say here, but there was a colleague of mine, not a FedSoc member, a Marxist as a matter of fact, who was resigning. He was resigning somewhat unexpectedly, and we were friends. I was chatting with him about why he was doing so, and he said it was because of all of the DEI investigations into him that his students were sponsoring for things he said in the classroom. He had enough money to retire, and he had just had enough. He was just done. I personally think, Ben, that because of your own skill and your own stances on these issues, you've just been a little insulated from something that's going on a very large scale. Respectfully.
Okay, so yeah, well, I appreciate the compliment, but substantively, I don't actually see much daylight between what you said and what I meant to be saying just before. I'm saying there is surely some, first, I think the amount of the chill varies by the classroom environment, and there are things that one can do under existing, law to make that better rather than worse. But two, surely there is some chill, and as I said, some conservative students tell me that. I'm offering a different theory of the mechanism, and therefore the main object of potential interventions, which I would identify as like culture. And what I would be interested in a conversation about, what are the things that contribute to this culture that I think is causing the chill? And I agree with you that on the faculty side, the causes may well be different. It may have more to do with the fear of formal sanctions, because they're not part of the social world that the students are part of, where these informal sanctions are imposed. So we disagree about so much of that.
That's clarifying, Ben. Thanks. In my experience, it's hard to get clear data about this, so a lot of it's anecdotal. In my experience, what the students are most afraid of is being outed as conservatives to potential law firms, their potential employers. That's the number one thing that scares them. They feel that they'll get fired or lose their professional opportunities. They feel that what they mainly feel is that other students will out them to their law firms. That's the number one fear that I hear. The next one is being deprived of, I guess you could call it professional opportunities of a student-mediated nature. That'll be things like getting excluded from the law review, for example, or from an editorial position on the law review because of their views. They're tougher than I would be with respect to the purely social sanctions. They don't like that, right? They don't like being ostracized and denounced, but they kind of expect it to the extent that they're FedSoc associated at all. I do think it creates a huge chill among people who haven't made the commitment to outing themselves, as it were, by joining FedSoc. On the professor side, they are really scared about the Office of Equity. They know about it.
So I actually think this is relevant to sort of Ben's first point about maybe it's a good idea to have this policy. And then the next question is to what extent can such a policy address these soft, on the student side, probably are more soft. I mean, we've all experienced it in class that you can, there are certain topics that sort of no one wants to talk about, or at least if they're on the, non-progressive side. And when there are debates, you could see people getting uncomfortable. I don't think our students I haven't been aware of my students sort of ratting each other out for something they said in class, but to what extent can a standard like this actually address those kind of soft sanctions? And they're real. I mean, I've heard stories at your law school, Ben, that sometimes conservative men will just skip rape day in crim because they don't want to get called on about consent. And so, that's a problem. That's a real problem. When you have those conversations, it's, on the faculty side, many I don't teach criminal law. My husband does. He teaches rape. But many his criminal law colleagues don't. So those are concerns. I don't just the question whether a standard like this can help. I think that to the extent it can, it's to send the message early on and often that we really mean it. And by the way, we're required to do this, and this is part of the profession. That would be the aspirational, not so much that the ABA at its site visit is going to like take away Notre Dame or Harvard's accreditation, but it gives us sort of an aspirational, like this is what the standard is trying to do, is to help us to explain to the students that we really mean this, and also hopefully affect disciplinary proceedings and other things.
So let me ask, we actually got an interesting question from one of the people listening that I think goes to sort of, I think to you guys as teachers, kind of how you practically in the real world deal with some of these issues when they come up. So someone gave the example of, what do you do if a student describes as racist the idea, they hear one student say, I'm against affirmative action, and then another student says, well, that's racist. Or you could imagine someone expressing, support for restrictions on abortion and being told, that's sexist or something. Do you as teachers feel an obligation to kind of intervene in an exchange like that and sort of, redirect people to how they think about it in terms of the merits, or do you just kind of let nature take its course with that? I mean, I think people listening to this are curious about how in the real world, if you're a teacher and you're trying to balance the pedagogical stuff with the free speech stuff, how do you, and you have students who might be reacting to things in ways that are, not helpful to robust discussion, how do you actually deal with that? Ben?
Yeah, so it's hugely complicated and highly context sensitive, right? So like for me, I teach like an 80-person constitutional law class. This would be a very different encounter in that setting than in a 18-person seminar I do about discrimination law and theory. I think, so maybe that's useful just for people trying to picture what this looks like. In the big class setting, there's content we're trying to get through, and the kind of meta issue of the conceptual inflation of racism is not something I have budgeted minutes for, and I don't think it's a setting in which it's likely to be productive to try to engage people. So what I'm honestly sort of hypothesizing this, but what I think I would do is say something to the effect of, people use that word to mean a bunch of different things these days. And so I think it's complicated. It might be more confusing than clarifying, and try to just kind of move past the use of that word, which I do think is complicated, and get at what is the person, if they can't use that word, what are they trying to say? And maybe they're trying to say, abortion restrictions have a hugely disparate impact on women in a way that ought to be of real concern, given context about political power and history, whatever. And if that's what they're trying to say, like, let's get that out. And then that's an idea that is very much within the four corners of what I want us to be spending class time on and discussing. Why is that relevant? Why wouldn't that be relevant? All of that. In the sort of seminar type setting where I feel less obligation to get through the stuff I had originally planned to get through, I think it could very well be fruitful to talk about the very thing that just happened, like what's at stake in somebody's use of this label of racist and racism, like what's going on with what kind of move in a language game is that, and sort of think critically about how that shapes the conversation. And still, what did they ultimately mean by it at the end of the day? But probably in a more open-ended conversational way versus a more kind of like managing the situation to try to keep the train on track kind of way.
Nicole or Josh, you guys have any thoughts on that?
I talk about, so first of all, I haven't had too many instances where a student accuses another student of racism or sexism or other forms of bigotry in the classroom. Sort of one person raises their hand and says something, and another one raises their hand and says, you're a racist, sexist, bigot of some other kind. I don't think that's ever happened. I have heard about things being said outside the classroom of that nature based on what was said in the classroom. So someone raises their hand and says, I oppose abortion, homosexual marriage, affirmative action, or any of the other sensitive topics, and get accused of racism for having said that in my class, but I haven't heard of it. I haven't heard it actually happen in the classroom. That said, I talk on the first day of class and in the syllabus about the importance of civility. And in talking about civility, the way I explain it is, you can say what you like about a person's views, but don't attack them personally. Don't attack them as identifiable individuals. So if someone raises their hand and says, I think affirmative action is wrong, and someone else wants to call that a racist view, I would simply allow it. It sure wouldn't be my favorite kind of conversation, but I think they would be free to say that in the classroom. But if they said, you're a racist person, I would say, wait a minute, we don't attack each other as individuals. And I think that's a line that can be policed. I mean, there is no line in this area that is perfect. We're not going to be able to draw lines about harassment or about accusation that are perfectly conceptually clean. But I think people understand intuitively the line between attacking a view and attacking an identifiable individual. And it's a line where we can say, here's what civility requires in a law school, and we can police that line.
I jump in? Sorry, Dana, go ahead.
I was just going to say briefly, I'm obviously not a law teacher like the three of you, and I think I greatly respect what you're saying about how to do this in the classroom, and very important. And let me just add, as a practitioner, in addition to kind of the teaching point about, hey, ethically we need to have civility and listen to opposing viewpoints and so forth, we're also teaching law students to be advocates, right? And so if you are the pro-life lawyer getting up to argue in front of a pro-choice judge, maybe it's not the best thing to start off with, I recognize that abortion restrictions are, alleged to greatly restrict women, and I don't have a problem with that. In other words, there's a point here about training students to present even controversial ideas in an effective way that goes directly to the heart of what we're trying to teach them to do ultimately. And I see that in practice all the time, and that you've got to take up a position that either because it's a cultural hot button or just because the judge doesn't like your client, right? You've got to go up and try to convince somebody who's hostile to you all the time. That's part of the job. And so just to, to keep the focus on that should, I think, help instruct how we teach students to address those situations in the classroom.
So Daniel, let me ask you, we had another question here that goes to another kind of practical issue, which is, how can we expect to have robust debate, and how can we expect all students to feel kind of free to express their ideas if there's discrimination against conservative and libertarian applicants to teach, to an extent that students who have those views don't really see anybody on the faculty who they can relate to and who's kind of sticking up for their viewpoint and letting them know that it's okay to have these views, et cetera, et cetera. It is, to the extent that that's a problem in any particular institution, is there anything that the ABA can or should do to try to push law schools to have more intellectually diverse faculty?
Well, the ABA more broadly, probably the answer is yes, but I assume the question's about the accreditation function.
Yeah, and I'm sorry, I know it's separate.
Yeah, as an accreditor, it's really hard. And I think probably the answer is no, because we do want to say you got to have a robust program of legal education, and you've got to support academic freedom if this standard passes, standard 208. But I don't know, even, you talk about administrability problems. I don't know how you would administer a standard that says, law schools have to, not discriminate on the basis of ideology when they're hiring. I mean, what if you get a Bernie Sanders professor who's way to the left and socialist in many economic policies, but says I support gun rights? Do you get points for, is that person 1/8 of a conservative because they have, certain viewpoints on guns. I don't know. I mean, it becomes very difficult to sort ideologically. And generally speaking, I don't think it's good for a regulator to be sorting ideologically. So that really would handcuff us. Now, should the ABA as a broad organization be supporting all viewpoints and making sure that lawyers are exposed to them in their education, that's generally a good thing. And I think the ABA more broadly could do that, but not in the accreditation function.
There's a connection between these problems. It's an interesting connection. There's a lot of research in psychology and social psychology about the effects of being in ideologically unified environments. They're quite striking. So experiments, for example, to the effect that if you take a bunch of people who are mildly concerned about climate change or mildly skeptical of climate change, put them in a room together to discuss climate change for 3 hours, two effects can be seen. They emerge from that room much more extreme in their views and much more certain in their views. So the mild climate change skeptics who thought, well, maybe it's happening, but it's not caused by human beings, or it's not a first priority problem, or something like that, they become climate change deniers. There's no such thing as climate change, it's a conspiracy. And the climate change supporters or people who are concerned about it who go into that same room and they're moderate, they think it's happening, it's a concern, there are other things to worry about as well. They come out thinking this is the most dire situation ever. So here's how that connects to our discussion of Rule 208. When you have a faculty and or a student body that has largely excluded conservatives and libertarians, where they are at most sort of tokens, that group of people will come to see speech as beyond the pale of decency, racist, bigoted, offensive, where most Americans wouldn't, where that same faculty wouldn't. So let's imagine hypothetical law school X. If hypothetical law school X has sort of a critical mass of conservative or libertarian or just heterodox thinking professors, including our Bernie Sanders who supports gun rights, if it has enough heterodox thinking professors, they will have one view of what constitutes racist, bigoted, unacceptable speech. And if they have a group of left professors, they will have a very different idea of what constitutes offensive or bigoted speech. I think a lot of what's happened in the elite universities of the country, especially, is the students and faculty have become so ideologically unified that their perceptions have bent as to what constitutes racism or sexism or transphobia or homophobia. And their sense of priorities has bent as to what it is we should be focusing on. So there is a connection between who gets in the door, who is a member of the community, and what speech is allowed. And I think the questioner was right to point out that connection and to say the more fundamental problem is who gets in the door. That said, I nonetheless think that this, given that we have law school faculties that are overwhelmingly left of center, with at most a little bit of tokenism on the conservative side for the most part, and almost as extreme with respect to students, I think protecting free speech actively and vigorously is a wonderful first step and very welcome. But there's another problem.
Nicole, before we switch to another kind of subtopic here, is there anything, Ben or Nicole, you want to add to that?
Well, so I would say, first of all, I think Daniel's right. First of all, I think this is a big problem. I talk to young people a lot who are interested in the academy. And if you're right of center, there's lots of reasons why you decide it's not going to work for you. And it's like they're counseling each themselves out way before we even get to the job market and the perceptions of what the job market might be and what it might be like to be untenured and whether or not you get your law review articles published in top journals. All these things are, it's a real, I think that ideological diversity should be a priority for the legal academy and maybe for the ABA more broadly. I agree though with Daniel that this accreditation function, I mean, there's really no good measure of it that an ABA accreditor could use to say you're in trouble because you don't have enough, people who like gun rights or don't like abortion. I just think that's very hard for an accreditor to monitor, but it is something that the academy should be worried about, that donors should be worried about, that students who are applying to law school should be worried about. And so and the faculty should be encouraging conservative and libertarian students to consider the academy, but because I think that there's a lot of self-selection. But I do think Josh is right too, like absent ideologic diversity, robust commitment to free speech is really even more important. And it's important to hire, hopefully, people who are maybe left of center, but are very committed to robust discussion, and that will make things better. And hopefully will also make it so that more conservative and libertarian students think that the academy is someplace that they might want to spend their lives.
Ben, any thoughts?
I think it's an incredibly complicated problem, and I'm reluctant to opine on it in a way that isn't going to do justice to it. I do think it's the shape of it is very different than the problem of the range of views that students express, because that problem, the sort of expression in the classroom problem, is a problem about sort of what's what people tolerate or have to be civil towards, even if they think it's a really misguided, benighted way of thinking about something, and even if they find it offensive. The faculty hiring issue doesn't have that shape for the most part. It's actually an assessment of like, what are the best ideas, who's doing the best work, and making that judgment in a way, you can certainly make that judgment in a way that's neutral as to what political party does this person contribute to? You're like, who knows? And it seems irrelevant. But the idea of making assessments about the quality of people's ideas in a way that just so happens to yield a distribution that is has no correlation with people's ideological commitments, to the extent that what they choose to write about is connected to their ideological commitments, it's never going to happen that those are going to be independent. So the question of how to assess, no, but what's really the best when you're unbiased about it, I think is just a very hard and kind of impossible question in a way that does not have the same structure as the issue about the range of views that are accepted, permitted, not disciplined, that kind of thing.
But there's an interesting connection between the two questions you've delineated, then. I think you're exactly right. With respect to student culture, the question is, especially as they see it, what is beyond the pale of what we need to be civil to? What ideas are so offensive we don't need to be civil to them? And for professors, when we're hiring, the question is, are these high quality ideas? What are we learning from these ideas? Are they creative and original and a contribution to knowledge? But the connection is, and this is based on the social psychology I was citing, when you have a highly ideologically unified setting, both discussions get distorted, and they get distorted in the same way. For the students in a highly ideologically unified setting, ideas that break the ideological unity among the students, ideas that are taboo in the formal sense, that there's an ideological unity that they're resisting. Those lines of taboo will become broader and deeper, and as it were, earlier in the discourse because of the ideological unity of the students. And for the professors, their own capacity to assess whether ideas are high quality will be similarly distorted by the same forces, by the forces that have excluded a number of ideas on the way in. There will be an environment in which, I don't know, thinking that the Constitution should be interpreted as written just seems risible to them. It seems ridiculous. It seems ludicrous, as it did for a time before the certain changes in the academy that have already taken place made that idea respectable. So in other words, the same sociological forces at work in both discussions, and professors aren't immune from it. For students, it has to do with what's beyond the pale. And for professors, it's what constitutes high quality ideas. But we are all subject to these near universal laws of the human mind in the social environment, which is which is when we're surrounded by similar thinking people, we will draw those lines of quality and acceptability differently than we do when we're in a group of ideologically diverse people.
Okay,
So
well,
the-
I want to make sure we get to one more thing here. So one of the things, when Daniel was giving his summary here, he mentioned that there are these, there's the requirements, but then there's the sort of carve outs. And we've talked about the harassment issue and the environment and all that. But one of the other ones we wanted to get to is this part of the standard says that consistent with the policy, a law school may, quote, adopt policies on academic freedom and freedom of expression that reflect the law school's mission, including a religious mission, so long as such policies are not in violation of the law and are clearly disclosed in writing to all faculty, students, and staff prior to their affiliation with the law school. So it occurred to all of us that that was another area where there's a lot of room for judgment in terms of how broadly you would how broadly schools might choose to define their mission in ways that relate to speech and everything. Obviously, there's flagging the religious mission issue. So I thought we could start with Nicole to kind of speak to that and any thoughts you may have on on the merits of this as a policy and what some of the sticking points might turn out to be.
Well, so I mean, at the highest level, I think it's critically important to recognize institutional mission, and particularly religious mission. I've spent my life at a religious school that draws different lines. I mean, academic freedom is complete for faculty at Notre Dame. There are rules that are probably not enforced very often about counter speech, and so, but different schools might address it differently. And I think recognizing institutional mission as a form of expression is important, along with recognizing religious liberty. If a Catholic or law school, for example, wanted to have a policy, this is not the policy where I teach, that all student, speakers, invitees, need to be cleared for, not being counter to the religious mission of the law school. I think that should be permitted, but with the caveat, I think the important language here is as long as the policies are clearly disclosed. And I think this is somewhere the accreditor can really do work. So if a Catholic, a Jewish, I mean, right now, for example, the yeshiva debate about the LGBT group would be a good example, right? So I think they have basically just stopped having student groups because they say, we're a Jewish school, we can't have this group. And there has actually been a really interesting debate in the yeshiva discussion about the LGBT group. I think it's undergrad, but in any event, that whether they've articulated their Jewish mission clearly enough to make clear that this is the kind of thing that they thought were off the table. And so I think that that's really important. It's important for religious groups because in some sense, it enables religious institutions to identify and to participate in the marketplace of ideas as an institution, and to tell the people that are coming to this community, this is who we are. And then I think the clear articulation is also important because this mission exception is broader, right, than the religious mission. So if a very progressive law school, I suppose, wanted to have a mission statement that said, we're not going to have the Federalist Society. We're not going to allow that because we just think that's off the table. I would think that would be a bad policy. But I think, the really important thing is it has to be clearly articulated, and it can't just be, we're for justice. And so therefore we're going to systematically keep saying no every time a pro-life speaker's, student group tries to invite a pro-life speaker. I think that is something the accreditor can do work with, is to actually make sure if you're claiming this mission, you have to say what it is and what it means. Because I do think the exception is important, especially for religious schools. But I also
let me ask you, what were you guys thinking? The religious mission kind of speaks for itself. What were you thinking of as far as other types of missions that would be relevant here that might come into play?
I think Professor Garnett said it exactly, that recognizes that there's a longstanding debate and sort of about the nature of academic freedom and whether it's held by individuals or by institutions. And this provision is meant to recognize that, and it does go beyond the religious mission. Now, as to whether or not any particular law school would adopt a policy to say, you know, we're about advancing progressive politics, and so we're not going to allow any FedSoc members to be on our faculty, you know, I think just looking at 208 in a vacuum, yeah, probably the law school would be able to do that. Whether or not any school now would be able to suffer the consequences of doing that, you know, in kind of its reputation and how it would be viewed from outside is another question. And the only check on it that I would add, and I've alluded to this a couple of times, is Standard 301 requires law schools also to have a rigorous program of legal education, right? So I think you have to comply with that standard, which means that if the mission that you say allows you to restrict academic freedom, even if it's disclosed broadly, if it is of a nature that it prevents kind of the core of legal education, which again is talking about controversial ideas and resolving these hard questions in society, if you're not doing that, then I think you'd have trouble under 301, quite apart from compliance with 208 C3. But Professor Garnett, I think, explained very articulately exactly what we were going after here.
I disagree with this institutional missions exception, and to some extent with, you know, I really worry that it's going to be the exception that swallows the rule. You're just going to have, they won't say we're going to ban the Federalist Society. What schools will say is, we're part of our mission is creating an atmosphere of equity, inclusion, and diversity, and then that will give them cause and justification for saying we're free to limit professors' academic freedom, to investigate them under our equity, inclusion, and diversity policy, et cetera, likewise with students, because of our institutional mission. We fall under the exception. So this is a very, very dangerous exception. It's also unnecessary, and it's unnecessary from two perspectives. One is, the three of you just had a discourse where you had a really hard time coming up with institutional missions aside from the religious schools. And that's because law schools don't vary that much with respect to their institutional missions. They're trying to provide good legal education. And there actually aren't a lot of law schools. I'm not aware of any law schools that are announcing really exotic institutional missions, like to build a law school devoted to the advancement of the Republican Party or the Democratic Party or the socialist reform of America's economy or something else that's just sort of off the wall. What they're committed to, and what under accreditation policies they're required to be committed to, is providing a good legal education. And therefore, you don't need to, if you think this is part of a good legal education, you don't need to craft an exception for their institutional missions. Now, there is an exception for religious missions. I don't think that's contrary to basic discursive freedoms of the kind protected in this policy. But in any case, you don't need to have an encompassing institutional missions exception. You just say designated religious institutions, which do have a formal designation under law already, are entitled to maintain their religious mission. Or you could say something as simple as, notwithstanding this policy, institutions entitled to religious liberty under the First Amendment are, of course, entitled to First Amendment religious liberty under this policy as well, which is, as a formal legal matter, just perfectly obvious, but maybe deserves announcing. So I would recommend radically revising, even striking this exception.
Okay, thank you, Josh. We are literally down to our last minute or so here. Let me just conclude by asking, there's been a lot of attention to law schools. I think there have been some unfortunate incidents at some schools that have brought attention to this. I think that, Daniel has acknowledged that to some extent, this positive development of these proposed policies are a reaction to that. Let me just ask you, Nicole, give you the last word. Is there, for people who care about free expression, robust debate, excellence in education, do we have grounds to be more optimistic about law schools now than we were a year and a half ago?
I don't know what, I mean, I'm optimistic that the ABA is paying attention to this, and I'm glad that they are. I don't know, like, why I mean, it seems things like this year has been a little calmer, but if we're thinking about the student shouting down of speakers and other things, I am absent, universities and law schools really embracing a robust free speech policies. I'm not that optimistic that it won't happen again. So I mean, I don't want to end on a negative note, but this is a good step.
All right, we got a lot of work to do. Alita, do you have any final words for us?
Yes, thank you. Thank you so much. On behalf of the Federalist Society, I want to thank our panelists and our moderator for the benefit of their time and expertise today. And thank you for the audience joining and participating in this event. We welcome listener feedback by email at info@fedsoc.org. Thank you so much, everyone, for joining us today. We are adjourned.
Thank you for listening to Open Minds, a Freedom of Thought podcast series interviewing the people who bring courage and independent thought to the challenges of today. To learn more, visit freedomofthought.fedsoc.org.